we have people treating this story like it's a political election are absolutely ridiculous in my own unprofessional opinion. The fact remains, almost all of us agree it's a highly circumstantial case, meaning for every point someone makes, there's a counterpoint that can be made. And it's all based off our own interpretation of the information in the court documents and in the hearings. But there's multiple points of view here, and this ASD conversation is no different. And if you want a masterclass on how to get Hippler to stop bombarding you with questions, listen to this. All that being said, everything's alleged. Welcome to the point. Let's get to it.
You know, if we didn't have 2.5 years of media coverage to know how Mr. Kohberger's physical presence has been perceived, the state might have a little bit more credibility with that argument that it's not relevant.
And I would dare everybody who believes Bryan is guilty of this crime to say she's wrong. Now, what's going on right here, for those of y'all that don't know, is the defense is simply saying the jury needs to know Bryan has ASD. And they need to know because basic human nature says that an individual is going to look at another individual and make determinations of that individual based off how they look. And Bryan's very rigid. He doesn't say much. There's not a lot of facial expressions. He seems to be doing a couple of odd things in court. And we all know, regardless of what side of the aisle you fall on, within this particular story, numerous stories have been ran where individuals analyze Bryan's behavior in the courtroom. We know it's human nature because we know we do it ourselves. And we know that the jury's going to do it as well. Now, the state wants to make the argument. All the judge has to do is give a jury instruction. But the defense is saying that's not good enough. And I have to say, knowing what I know about human nature, I agree with the defense in this particular situation. Now, in terms of ASD being a factor as to why Bryan was caught wearing gloves and rooting through the trash can, that's going to depend on a couple of things. For example, if the defense can get up there and say, on the night of Bryan's arrest, law enforcement kicked in those doors because they had reason to believe that Bryan was destroying evidence because he was up at an odd hour and he was rooting through the trash can wearing gloves, and the state can't produce any evidence of what Bryan was attempting to destroy, I gotta say ASD could play a factor. On the flip side of that, if the state gets up there and says we had reason to believe Bryan was destroying evidence when he was rooting through the trash, and when we busted in the door we caught him destroying evidence, this whole ASD conversation gets a little bit less important. Which goes back to what I said at the beginning of the video. This is a circumstantial case, so the story means everything. And the one thing I know for sure, not anybody making videos about this particular case know the full story. The biased coverage benefits no one.
But we have extensive media coverage that refers to him as evil, as an incel, as looking like a monster with very dark eyes. And it's all based on their analysis of him sitting in the courtroom. Pardon?
None of that is his autism spectrum. Well, you just mentioned.
But his physical presence is what the media has been judging, which is the same thing that a jury is going to do. So my point is that for the state to say that it's not relevant, we actually have in this situation the ability to point you to the fact that that is not true. Because what the media has done, I mean, there are, even before the cameras were cut out of the courtroom, there were all kinds of zooming in and stories with experts doing body language studying about him, including the fact that this is how he holds his hands, and there's details about that. So it's disingenuous to say that he's not going to be judged by his appearance. That is exactly what jurors are doing. They're judging the evidence. They are staring at the accused. They're looking for an accused to be remorseful and emotional at evidence that makes everybody else feel bad, and he is not capable of doing that through no fault of his own. And there is, I just explained to you that there are studies that have been done and there's case law on this, that it's important that the jury be informed.
There's also a case law that says that none of what happens except in the testimony is relevant. So how do I square those two things?
And people give Judge Hippler a lot of crap about this particular question. He's simply saying the case law, which guides his decision, says that only during testimony does this apply. But watch how Bryan's attorney sets this up, and you'll see a change in tone and question from Judge Hippler.
Because
I give the jury an instruction that specifically says, don't judge this case based on anything except that you hear on that witness stand. And then if I do this, what you're asking me to do, I'm basically telling them, but, that's okay.
Well, the state's asking you to give a jury instruction that says that. We're asking you to let us
Part of
put
the standard
testimony on.
instruction is that the jury may not consider as evidence anything other than the testimony and exhibits admitted in the trial.
But Judge, I just
Here it
quoted
comes.
cases to you where we don't get to live in a state of denial, right? We can pretend, but that's not what exists in society.
I
So
have to
we
live
don't
in
get to live in a state of
what the law
denial.
is my concern.
Pardon?
I have to live in a state with what the current state of the law is
And
in
I
Idaho.
I just gave you
You
examples.
gave me no Idaho cases.
But Judge, you can have the courage to be the first one to set it right here.
And that's the moment you start to see a change in how Judge Hippler acts and what his questions will be. Because there is case law all across this country that says this type of stuff has to come in, the jury has to be aware. Because basic human nature says an individual is going to make judgments based off how another individual acts and behaves. And you'll hear how the entire dynamic within this conversation starts to change.
Then, because autism spectrum disorder is very real in our society. 1 in 59 people have it. 4 times more common in males.
I'm not in any way trying to downplay those that may be diagnosed on the spectrum. I'm trying to figure out how do I do this where I have settled legal precedent that I'm supposed to follow that says the jury may not consider as evidence anything other than the testimony at the witness stand. They can't consider, they're not supposed to consider the demeanor.
But
of
they
the
do,
witness. Now,
and
I
you
will
know
say,
it.
having seen Mr. Kohberger over numerous days now, I haven't seen anything unusual in terms of his demeanor. But, I'm not, scrutinizing him on YouTube the way maybe others are. But I understand
Cat got your tongue?
your concern, and I'm not trying to downplay it. I'm just trying to understand how I get there in light of the legal requirements that I'm supposed to tell the jury, don't consider any of that. Maybe the way is to say, the way the parties appear, what happens at council table is not evidence. You shouldn't be concerned about it, and it should play no role in your decision. Would that do it?
Judge, the proper way to do this is through testimony. I just went through a litany of cases where that's what the courts have said in other states is the way to handle it.
I don't think those cases were those cited to it?
They're not Idaho cases, no. But then it's an issue of first impression here, right? And so you get to make the decision, and you can get it right. You can allow the testimony, right? I mean, if it's an issue of first impression and you're looking for guidance around the United States, then do what other states are doing. That's the solution, not a jury instruction.
I'll take the matter under advisement.
And at that moment, Judge Hippler was speechless. He had no follow-up questions. He understood exactly what the defense was saying. And a lot of people need to understand, when you're dealing with an individual like this, that doesn't mean they dislike you. That doesn't mean they're biased. They're just simply trying to understand. They're trying to make determination based off what the rules say they can and can't do. So when you answer a question and satisfy all those questions, you'll notice there will be no follow-up questions. This was, in a lot of ways, a masterclass on how to deal with someone like that. Once again, that doesn't make him biased. He has said multiple times he is limited to what he can do within the law. And the law is what he's supposed to follow. Now, one of the idiotic things that I heard when reading comments and watching videos on this particular story is individuals are saying the defense just simply wants to throw out all the evidence. That they're up there telling the judge, we don't like this evidence because it's bad for my client. And I understand that, but for all of you who believe Bryan is guilty, what in the hell is the defense supposed to do? Honestly, if they're not doing that, then that only means one thing. That means Bryan's not getting a fair trial, he's not getting a fair shake, he's not getting adequate representation, and you won't get justice. If the defense does not try to toss this evidence out, they're not doing their job, and the only way you get justice is if both sides do their job and do their job within the law. So stop being so childish in your breakdown of this thing. And there are parts of this whole ASD conversation where I do believe the state scored a couple points, mostly pertaining to the DP. And here's what I'll say about that. I am not opposed to the DP. I believe it's a states' rights issue, and I believe in states' rights. That being said, it should only be reserved for the worst of the worst. And it should also be set at the highest bar for the state to prove. I don't believe this is something that should be passed out like candy, where anybody and everybody gets a DP sentence when they do something awful. And in the event Bryan is found guilty and it's determined he's among the worst of the worst, I do believe the DP would be appropriate, depending on how the rest of the story plays out. But the defense is saying Bryan has ASD, and because he has ASD, the DP should be thrown off the table, and they cite some cases and they make their point, and I get it to a degree. But I believe the state made the better argument in this particular situation. I know it's going to upset a lot of people, but I'm just calling it like I see it. Mainly for this particular reason and this reason only. When you talk about somebody who committed an absolutely horrific crime and they are diagnosed with something, you would expect to see some sort of mental capacity that is diminished. Meaning if an individual had ASD, for example, and he was also the type of person that would fart and giggle in a bathtub, I could get throwing the DP out in that particular situation. Obviously, not everything's cooking upstairs with those type of people. But as this pertains to Bryan, I don't believe that the defense made a good enough argument, mainly because this guy's getting a PhD. Obviously, he has the mental faculties to understand right or wrong. Now, him not having an ability to express emotion doesn't mean that he doesn't understand what he can and can't do. If he has a bachelor's, master's, and was seeking a doctorate in criminology, I believe it's a safe assumption to say most rational people are going to say this guy knows right from wrong. And I believe the defense fell flat in that particular argument. Even when you go back and look at that one police video where he got pulled over in Pullman, and in fact when he got pulled over going back to PA, he was able to have a normal conversation. He looked like a fully functioning individual. Those body cams didn't walk up to the car and catch Bryan Kohberger sniffing his farts. He was having a conversation. He was having a rational conversation. I don't think ASD in this situation on its own is enough to throw the DP out. Once again, it is a highly circumstantial case. There is points and counterpoints to everything that has been talked about. And whether he gets it or doesn't will depend on who can tell the better story. But I caught a couple other individuals giving interviews and talking about this particular part of the story on mainstream media, and I absolutely said this is some of the dumbest coverage I ever heard. Both sides made points here. ASD should be a factor that the jury will know, because basic human nature will say they will determine, at least to a degree, whether Bryan is guilty or not guilty based off his appearance and based off how he acts during trial. But I don't believe it's enough to simply say the DP should not apply in this particular situation. As always, this is an open discussion channel and you can feel free to disagree at any point in time. But if you enjoy this and a more fair, open conversation, maybe check one of these videos out. Y'all be safe now.